Good morning. Today we are going to discuss the vicarious liability between the master and the servant. A master is liable for the wrongs done by his servant in the course of his employment to third parties. Means what happens? The servant is doing the master's acts, or he is performing his duties towards the master. At that time he commits some tort, because of which third person suffers. So for the third party, vicariously the master will be liable. Now first of all we have to see who is a master and who is a servant. A servant is a person who is in the course of employment doing his duties towards the master. Means what the master has done? Master appoints the servant. Master can remove the servant. Master keeps control over the works of the servant, and the master pays him. These four things must be there. If these four things are there, the relationship between the two persons can be called as master and servant. So who is a servant? Servant means a person who is appointed by the master. He can be removed at any time by the master. The payment is done by the master. And the most important is, whenever the servant is doing his work in the course of employment, the whole work can be supervised, or it is being controlled by the master. Then this person is a servant. Now this servant is doing his duties towards his master in the course of employment. Whatever he does, for that the master is liable vicariously. Means a tort will be treated within the course of employment if it is done in certain circumstances. That is, we have to see that when master is liable for torts of his servant. The first is when the servant is doing his authorized acts and its natural consequences. Whatever happens of that authorized act, the master is liable. In the previous lecture itself we have seen respondent superior. Let the superior be responsible. The master is superior. The master is authorizing the servant to do certain things, and that servant is doing those things with the directions of the master. So he is doing the authorized work. So whatever happens in that work, whatever natural consequences occur, the master will be liable. So master is liable for authorized act and its natural consequences. The other is incidental acts. Incidental acts means connected act, authorized act and incidental acts. Means when the master has authorized the servant to do certain things, he is doing it. But slight changes he can make, isn't it? He has to take his lunch, his dinner, he has to sleep. So certain decisions he will take for himself. The servant will take for himself. So whatever decision he has taken for himself, which are connected to the authorized act, it is not like complete opposite things he is doing. He is doing it within the scope of his authority, within the course of his employment. So whatever he does incidentally, connectedly to the authorized act, the master will be liable. This is a second, you can say, circumstances where the master is liable for the torts done by the servant to third persons. Now the third is unauthorized modes of authorized act. Listen carefully what I am telling. Unauthorized modes of authorized acts means the master has authorized the servant to do certain things. The servant is also doing those things only, but while doing it, he is not doing it properly. That is unauthorized modes of doing authorized act. Means what this servant is doing, he is performing his duties in the course of employment. He is doing everything which is authorized, but he does it negligently. He does a mistake. He does a fraud. Means he is doing authorized acts, but within that authorized act, he is not acting in a proper manner. For third person, the master is liable. The master here cannot take a defense to a third person that, see, he himself the servant has done negligence, the servant has done fraud. No, for third person, For the third person, the master himself is liable. Within the master and servant, they can make liable each other. But for third person, the master himself is liable, because we are here created vicarious liability for the protection of third persons, so that the third person should get compensation. So here we will see unauthorized modes, few unauthorized modes of authorized act. Take example of negligence. The master has appointed the servant to do certain things. While doing it, he does not take care. As he does not take care, some wrong occurs and third party is at loss. Where the third party will go, na? The third party is going to ask or going to claim compensation from the master himself. For negligence of the servant, the master is liable. Mistake of a servant, means the servant does a mistake. Like one case is there, Ballet versus Manchester Railway Company. In this case, what the porter, he feels, the train has started just now, it is in a very slow speed, and he feels that Ballet, that is a plaintiff, is sitting in a wrong train. We don't know why he feels or not, but he feels that he is sitting in a wrong compartment or a wrong train. So what he does not ask him anything. He just pulls him and pushes him out of the railway, pushes him out of the compartment. So the Ballet faces severe injuries. Therefore, he has filed a case. And poor Ballet was sitting in a right train. We don't know why the porter has done these things. So porter is a servant of the railway. He has done a mistake. Though he has done a mistake, the master is liable. That is, the railway company was liable for Ballet for paying compensation, though the mistake was done by the servant. Getting it? Means though the servant does a mistake, though the servant is negligent, the master is liable to third person. The next we'll see fraud. That is, now the servant is doing here fraud against the master. But who has appointed him? The master. So third party faces any loss. For third persons, the master will be liable. Master here cannot take a defense. See that he has done fraud against me. You both do anything. Loss is between yourself, you make liable each other. But for third person, the master will be liable. We'll see one case. Lloyd versus Graysmith and Company. A old lady, she comes to a solicitor and she is telling him to do some paperwork so that one property which she has purchased, she wants to make that property in her name. So she gives all the papers to the solicitor. What the solicitor does, he appoints his junior to do that work. Maybe that is a simple work, so he appoints a junior. And what this junior does, he does such a kind of paperwork that the whole property is in the name of the junior now. So he has committed fraud against his own master, that is the solicitor. But for the lady, the solicitor is liable because she came to the solicitor. She asked his services, but the solicitor has delegated, has given the work to somebody else, that is a junior, that is a servant. Here we have taken the relationship as a servant. Now the servant has committed fraud, but for third person, the master will be liable. So these are the unauthorized modes of authorized act. There are many unauthorized modes of authorized act. Like the master has told the servant, he has given some directions to him, so you have to take care, you have to do the work in a proper manner. He has given a lot of lecture to him. He has given him lots of instruction to take care and to do the work properly. But what the servant does, the servant willfully disobeys the master's direction. So he is doing some wrong towards the master himself. Yes, he is doing some wrong. Therefore, we are calling here it as unauthorized modes. But third party is at loss. As the third party is at loss, for the third party, the master will be liable. So if he deviates also, if he gives lift to unauthorized persons also, if he willfully disobeys also, if he commits fraud also or mistake or he is negligent for all these unauthorized modes, the master is liable, because mainly those are authorized acts. Therefore, the main concept is the master is liable for authorized acts and its natural consequences. The master is liable for unauthorized modes of authorized act. The master is liable for incidental acts also. Then you are going to ask me, ma'am, when the master will not be liable? Master is not liable for the servant's unauthorized act. Means if the servant does some unauthorized act, then the master can say, see, this is unauthorized, I am not liable. You yourself personally are liable. But here also one thing is there, that if the master ratifies the unauthorized act, then the master is vicariously liable, because we have seen by ratification a master can be made, one person can be made liable for unauthorized act. We'll repeat. Master is liable for authorized act. Master is liable for unauthorized modes of authorized act. Master is liable for incidental acts. Master is liable in these three different circumstances. Master is only not liable for unauthorized act, but if he ratifies it, then the master becomes liable. Got it? Bye bye. See you in the next video.